Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or professional advice. The historical legal frameworks and precedents discussed, including the evolution of family law and divorce statutes in the United States, are complex and subject to change across different jurisdictions and time periods. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any specific personal or legal matters. The information presented here reflects historical trends and case studies, rather than a definitive guide for current legal proceedings. In 19th century America, getting a divorce was not a matter of paperwork. It was a matter of high-stakes theater. Imagine a husband and wife who both desperately want to separate, but the law in their state strictly forbids divorce unless one party can prove the other committed a heinous act of adultery or extreme physical cruelty. To escape a dead marriage, these couples would hire professional correspondents, actors or strangers who would be photographed in a hotel room with the husband, fully clothed but looking suspicious, just to provide the evidence required by a judge. This era of collusive divorce turned the American courtroom into a stage for manufactured scandals, creating a legal fiction that millions of people had to participate in just to regain their freedom. Today we look at the modern system and often wonder why it feels so adversarial, expensive, and bureaucratic. The reality is that the ghost of these ancient laws, specifically the frameworks that led to the Divorce 661, historical context, and the evolution of evidence codes, still haunts our family courts today. If you have ever felt that the legal system is designed to make conflict worse rather than better, you are not imagining it. The system was built on a foundation of fault, blame, and moral policing that took over 2 centuries to dismantle, and in some ways we are still living in the wreckage of those Victorian-era policies. This deep dive masterclass is designed to solve one primary problem for you today. It provides the essential historical map to understand how the American legal system views your marriage, your assets, and your rights. By understanding the historical context of marital dissolution, you gain the perspective needed to navigate modern complexities. We are going to explore the transition from legislative divorce, where you literally needed an act of Congress or a state legislature to end a marriage, to the divorce mills of the 1800s, and finally to the 1969 no-fault revolution that changed everything. We will examine the data behind the shifting rates of dissolution and look at case studies of how specific legal codes, such as those governing the presumption of legitimacy and the division of community property, evolved from colonial necessities into modern-day statutes. This is not just a history lesson. It is a tactical breakdown of the legal DNA that defines family law in the United States. To understand where we are, we have to go back to the American colonial period, where the legal landscape was a fractured mirror of English common law. In the early 1700s, the concept of divorce, as we know it, barely existed. Instead, the colonies were divided by religious and regional philosophies. In the southern colonies, like Virginia and the Carolinas, the influence of the Anglican Church was so strong that absolute divorce, divorce vinculo matrimoniae, was virtually non-existent. If you were in an unhappy marriage in Virginia in 1750, your only real option was a divorce from bed and board, divorce mensa et thura, which was essentially a legal separation. You could live apart, but you could never remarry. You were legally tethered to a ghost for the rest of your life. This created a massive social crisis as the population grew, leading to a rise in self-help divorces, people simply walking away from their spouses and starting new lives in different colonies under assumed names. This historical trend of desertion was the primary method of marital dissolution for the working class for over 100 years. In contrast, the Puritan colonies of New England, particularly Massachusetts and Connecticut, viewed marriage not as a divine sacrament that was indissoluble, but as a civil contract. Because it was a contract, it could be broken if one party breached the terms. However, the breach had to be severe. This led to the rise of legislative divorce. If you wanted to end your marriage in the late 1700s, you didn't go to a judge. You went to your local representative. You had to petition the state legislature, presenting a bill that would specifically dissolve your marriage. This was an incredibly expensive and public process. Only the wealthiest and most influential citizens could afford to lobby the legislature to pass a private law just for them. Case studies from this era show that the legislature would often read the gruesome details of a couple's domestic strife on the assembly floor, making the most private moments of a person's life a matter of public record forever. As the 1800s progressed, the United States saw the emergence of migratory divorce, which is one of the most fascinating historical trends in the legal world. As different states began to realize that they could attract wealthy travelers by offering easier divorce laws, a competition began. This is where we see the birth of the divorce mill. In the mid-19th century, Indiana became the first major destination for what was then called divorce tourism. Indiana's statutes allowed for divorce on the grounds of any other cause for which the court shall deem it proper. This vague language was a massive loophole. Thousands of people from New York and Massachusetts, where laws were still incredibly strict, would travel to Indiana, stay for the minimum residency requirement, and get their decree. The data from this period is staggering. Between 1867 and 1886, the first federal investigation into the matter, known as the Wright Report, found that divorce rates were skyrocketing far beyond what anyone had predicted. The report showed that while the population of the U.S. had increased by about 60%, the number of divorces had increased by nearly 157%. This sparked a moral panic across the country. Conservative legal scholars and religious leaders began pushing for uniform divorce laws to stop people from jumping state lines to find more favorable courts. This tension between state sovereignty and the full faith and credit clause of the Constitution created a legal gray zone that lasted for decades. If you got a divorce in Indiana but moved back to New York, was your divorce valid? For a long time, the answer was a terrifying maybe. In the landmark case of Haddock versus Haddock in 1906, the Supreme Court ruled that a state did not have to recognize a divorce granted by another state if the court didn't have personal jurisdiction over both spouses. This meant a person could be legally divorced in one state and still legally married, and committing bigamy if they remarried, in another. This historical complexity is the direct ancestor of the modern jurisdictional battles we see today. The 661 context refers to the refinement of these evidentiary rules, how we prove residency, how we prove the intent to remain in a jurisdiction, and how we handle the presumption of a valid marriage. As we move further into this masterclass, we will see how these 19th century shams and loopholes eventually forced the hand of the legal system to create the no-fault standards we use today. By examining these potential outcomes in historical case studies, we can see that the current system wasn't designed for efficiency. It was designed as a series of patches to fix a broken, 200-year-old boat. In the next section, we will break down the specific shift in the 1960s that finally killed the fault system, and how that single change fundamentally altered the economic landscape for American families. To truly grasp the magnitude of the shift that occurred in the mid-20th century, we have to look at the psychological and legal trap that was the fault-based system. Before 1969, the American legal system treated marriage as a fortress that could only be exited if one person committed a crime against the institution. Imagine if you are a man named David living in New York in 1958. You and your wife have simply grown apart. There is no abuse, no gambling, and no infidelity. You both agree that the marriage is over. In 1958, the law effectively told you that your agreement did not matter. To get a divorce, David would have to sue his wife or she would have to sue him. One of them had to be labeled the guilty party and the other the innocent victim. This created a perverse incentive for perjury. Legal historians have documented thousands of cases where couples engaged in what was known as the hotel room setup. David would hire a private investigator and a woman to meet him in a hotel. They would sit on the edge of a bed, fully clothed, while the investigator snapped a photo. This manufactured evidence of adultery was then presented to a judge who, in many cases, knew exactly what was happening but accepted the charade because the alternative was forcing two people to remain in a miserable union. This era of legal theater was not just a social nuisance. It was an economic weapon. Under the fault system, the innocent party usually walked away with the lion's share of the marital assets and a lifetime of alimony. If the husband was the guilty party, he was essentially ordered to pay a penalty for his breach of the marriage contract. This was not about equity or need, it was about punishment. Historical trends show that this created a massive barrier for women who were often financially dependent on their husbands. If a woman was found to be the guilty party, perhaps she was the one who left, she could be stripped of all financial support and lose custody of her children based on her perceived moral failure. This was the landscape of family law before the 1960s. A system built on blame, manufactured scandal, and rigid moral policing. Then came 1969, a year that would fundamentally rewrite the social contract of the United States. In California, Governor Ronald Reagan signed the Family Law Act, which introduced the nation's first true no-fault divorce. Reagan, who was the only U.S. president to have been divorced, later called this the greatest mistake of his political career, but at the time it was seen as a necessary move to end the rampant perjury in the courts. The logic was simple. If a marriage was broken, the state should not care why. The new standard became irreconcilable differences. This change effectively transformed marriage from a permanent status overseen by the state into a terminable contract. It was a legal earthquake. Within a few years, almost every other state followed California's lead, though New York remained the final holdout until 2010. The economic landscape for American families was altered overnight. With the removal of fault, the focus of the court shifted from punishment to settlement. We began to see the rise of community property and equitable distribution models that focused on the length of the marriage and the contributions of both parties, rather than who did what to whom. However, this shift had unintended consequences. Data from the 1970s and 1980s indicates that while no-fault divorce made it easier for people to leave toxic situations, it initially led to a significant drop in the standard of living for divorced women and children. The old system of permanent alimony was replaced by rehabilitative alimony. It was intended to provide support only until the recipient could become self-sufficient. This assumed that a woman who had been out of the workforce for 20 years could suddenly jump back in and earn a living wage in a 1970s economy. It was a transition period defined by massive financial instability for millions of households. Fast forward to the current year, 2026. We can now look back at this historical trend and see how it birthed the modern procedural codes we use today, including the frameworks often referenced in the Divorce 661 context. The 661 designation often refers to the specific evidentiary standards and jurisdictional requirements that evolved to prevent the type of forum shopping we saw in the 1800s. In 2026, the legal system relies on a highly digitized and formulaic approach to dissolution. We have moved from the high drama of the hotel room setup to the clinical precision of the child support guideline calculator. But the historical DNA of those 1960s reforms is still there. For example, consider a modern case study involving a couple named Sarah and Mark. In 2026, if Sarah decides to end the marriage, she does not need Mark's consent, and she does not need to prove he did anything wrong. This is unilateral divorce, a direct descendant of the 1969 California reform. However, the ghost of the fault system still lingers in the background of certain financial negotiations. In some jurisdictions, if one party has committed financial misconduct, like draining a joint savings account to fund a secret lifestyle, the court can still factor that behavior into the division of assets. This is the modern evolution of fault. It is no longer about moral failure. It is about financial transparency. The transition to the no-fault era also fundamentally changed how we view the role of the father in the American family. In the fault-based era, custody was often used as a bargaining chip or a reward for the innocent party. The 1970s and 80s saw the rise of the best interests of the child standard, which moved the focus away from parental rights and toward child welfare. This sounds like a positive shift, but in practice it created a new kind of adversarial system. Instead of fighting over who was the bad spouse, parents began fighting over who was the better parent. This led to the professionalization of divorce, with a massive influx of custody evaluators, forensic accountants, and mental health professionals into the courtroom. The cost of ending a marriage skyrocketed, not because of the legal fees to get the decree, but because of the auxiliary services required to prove a case in a no-fault world. By examining these historical case studies, we see that the 661 context is part of a larger effort to standardize these complex interactions. The legal system in 2026 is an attempt to create a predictable outcome for a highly unpredictable human experience. We have traded the moral high ground of the 19th century for the bureaucratic efficiency of the 21st. But this efficiency comes with its own set of problems. As the process became easier to initiate, the volume of cases overwhelmed the courts, leading to the rise of alternative dispute resolution, such as mediation and collaborative law. These are the tools we use today to keep families out of the very courtrooms that were designed to judge them a century ago. But what happens when the legal system encounters a technology it wasn't built to handle? We have discussed the transition from legislative acts to no-fault decrees, but we haven't touched on the next major frontier, the digital asset. As we dive into the next phase of this masterclass, we will explore how the historical definitions of property are being challenged by the rise of intangible wealth. What happens when the most valuable asset in a 2026 dissolution isn't the house or the car, but a digital legacy? And more importantly, how are the courts using these historical codes to decide who owns the future of a family? The next part of our deep dive explores the high-stakes world of modern asset tracing and the secret ways the 661 framework is being used to find hidden wealth in a world that has moved beyond the physical. To understand how we trace wealth in a world of invisible digits, we have to look at the bedrock of American evidentiary law, the 661 presumption. Historically, this framework stems from California Evidence Code Section 661, which establishes a simple but devastatingly powerful rule. A person who exercises acts of ownership over property is presumed to be the owner of it. In the year 1872, when this code was first drafted, this meant that if you were seen riding a horse or tilling a field, the law presumed that horse or that land belonged to you. But as we sit here in 2026, the definition of an act of ownership has undergone a radical high-tech transformation. In modern dissolution proceedings, the 661 framework is the primary lever used by forensic accountants to crack open hidden offshore accounts, decentralized finance protocols, and fractionalized real estate holdings. Imagine a scenario in 2026 involving a couple we will call John and Maria. They have been married for 15 years, a period during which John built a successful consulting firm. As they enter the divorce process, John provides a financial disclosure that shows his bank accounts are nearly empty. He claims the economic downturn of the mid-2020s wiped out his liquidity. However, Maria's legal team notices a discrepancy. John is still traveling on private suborbital flights. His social media shows him wearing high-value wearable tech that costs more than a mid-sized sedan, and he is frequently seen at a residence in a jurisdiction that does not share tax data with the United States. Under the historical trends of the old fault-based system, Maria would have had to prove John was lying through a grueling process of subpoenas. But under the 661 framework, the burden of proof flips. By demonstrating that John is exercising acts of ownership, specifically, that he is the sole beneficiary of these high-value services and properties, the court applies the 661 presumption. The law now presumes John owns the underlying assets that fund this lifestyle. The tactical shift here is monumental. John can no longer simply stay silent and wait for Maria to find his money. Instead, John must now provide evidence to prove he does not own the assets. He must show that some other entity, perhaps a complex trust or a foreign corporation, is the true owner and that he is merely a guest. If he cannot provide that evidence to a high degree of certainty, the court will treat the estimated value of those hidden assets as community property. This potential outcome often leads to a massive settlement before the case even reaches a final trial. The historical evolution of this framework is deeply rooted in the transition from physical assets to beneficial interests. In the early 1900s, asset tracing was a matter of looking at physical ledgers and property deeds at the county recorder's office. If a husband wanted to hide wealth, he would buy gold bars and bury them or put a deed in a cousin's name. The courts developed the concept of the resulting trust to combat this, arguing that if one person paid for a property but put it in another's name, a trust was automatically created for the benefit of the payer. The 661 framework essentially codified this common-sense observation into a formal evidentiary rule. By the mid-20th century, as the United States became a global financial hub, the complexity of these cases grew. We saw the rise of the alter ego doctrine, where a spouse would use a corporation as a personal piggy bank. The 661 presumption became the tool used to pierce the corporate veil, allowing judges to treat corporate assets as marital property if the spouse treated the company as their own. In 2026, we are seeing the 661 framework applied to the most complex asset class in human history: the digital legacy. Digital legacies include everything from high-value domain portfolios and social media monetization rights to neural net training data and cryptographic tokens. In the case of John and Maria, the forensic team might use AI-driven scrapers to monitor John's public interactions with various digital platforms. If John is seen managing a specific digital art collection or voting on the governance of a specific autonomous organization, those are acts of ownership. Even if the assets are stored in a hardware wallet that John refuses to surrender, the 661 presumption allows the court to assign a dollar value to those assets and offset them by giving Maria a larger share of the physical assets, like the family home or retirement accounts. Step by step, the modern asset tracing process under this framework follows a rigorous path. First, the tracing team establishes a baseline of known income versus known expenditures. This is often called the lifestyle analysis. If there is a gap, a lifestyle that exceeds the reported income, the 661 presumption is triggered. Second, the team identifies the nodes of control. In 2026, this means identifying which biometric signatures or digital identities are interacting with the suspected assets. Third, the legal team files a motion for a preliminary finding of ownership based on Section 661. Once the judge signs off on this presumption, the high-stakes game of chicken begins. The non-disclosing spouse must either reveal the assets to prove their value is lower than estimated, or they must risk the court awarding the other spouse a massive judgment based on the presumed value. This is where the 661 framework becomes a double-edged sword. While it is designed to ensure transparency and equity, it can also lead to cases of extreme financial pressure. For example, consider a case study involving a small business owner who has kept poor records. If the court presumes the business is worth significantly more than it actually is because the owner has been using the business account for personal errands, an act of ownership, the owner might be forced to liquidate the company just to pay out a settlement based on a presumed, but non-existent valuation. This historical trend of the professionalization of the courtroom means that the winner is often the party with the better data, not necessarily the party with the better moral argument. Furthermore, we must examine how the 661 framework interacts with the concept of separate property transmutation. In many states, assets owned before the marriage are considered separate. However, if a spouse exercises acts of ownership over those separate assets in a way that mingles them with community efforts, such as using community funds to pay a mortgage on a separate property or managing a premarital investment portfolio daily, the 661 presumption can be used to argue that the asset has been transmuted into community property. This is a common pitfall for high-net-worth individuals who believe their premarital wealth is untouchable. The historical record is full of case studies where a 20-year marriage resulted in the total loss of separate property status because the owner could not overcome the presumption created by their own actions. As we move deeper into this masterclass, the stakes only get higher. We have looked at how the law views the present state of your assets, but what about the future? The most contentious part of any modern divorce isn't just what you own today, but what you are capable of earning tomorrow. The historical shift from permanent alimony to temporary support has created a new battlefield where the 661 framework is being used to evaluate human capital. What happens when your greatest asset isn't a bank account, but your reputation, your professional license, or your future earning potential? In the next part of our deep dive, we will explore the controversial world of celebrity goodwill and the valuation of the professional persona. We will see how the courts are now putting a price tag on fame and skill, and why your career might be the most expensive thing you ever have to divide. Filing for divorce in California. This video provides a foundational look at the procedural steps for starting a divorce in California, which is the primary legal environment where the 661 framework and asset disclosure rules are most strictly applied and evolved. Zero views. The concept of professional goodwill represents one of the most significant shifts in American family law, moving the definition of property from the physical to the purely conceptual. To understand how the 661 framework applies here, we must first look at the historical trend of valuing human capital. For centuries, a person's ability to earn a living was considered a personal attribute, not an asset that could be divided in a divorce. However, as the United States economy transitioned from manufacturing to services and information, the legal system had to adapt. This led to a monumental question. If one spouse supports the other through medical school, law school, or the buildup of a professional practice, does the supporting spouse own a piece of that career? In the mid-1980s, a landmark case study titled O'Brien v. O'Brien in New York sent shockwaves through the legal community. The court ruled that a medical license was, in fact, marital property subject to equitable distribution. This was a radical departure from the norm. The court's logic was that the license represented enhanced earning capacity that was acquired during the marriage through the joint efforts of both spouses. While many states, including California, eventually moved away from treating a literal license as property, they replaced it with the concept of professional goodwill. This is defined as the expectation of continued public patronage. It is the value of a business or a career that exceeds the value of its physical assets like desks, computers, or bank accounts. Now, imagine a scenario in the current year 2026. Meet a character named Leo. Leo is a high-level software architect who has also developed a massive following as a digital consultant and social media personality. He has spent the last 10 years of his marriage building a personal brand. His wife, Chloe, managed the household and provided the emotional and financial stability that allowed Leo to take risks and build his digital empire. As they enter a dissolution in 2026, the 661 framework becomes the central part of their financial battle. Specifically, we are looking at the intersection of California Evidence Code 661, the presumption of ownership, and the procedural pressure of Local Rule 6.6.1, which governs the mandatory settlement conference. In this high-stakes 2026 environment, the 6.6.1 mandatory settlement conference is the final gatekeeper before a full trial. This is the room where the 661 presumption of ownership is weaponized. If Leo has been exercising acts of ownership over his digital brand, controlling the passwords, signing the sponsorship deals, and managing the AI-driven content engines, the law presumes that the brand and all its associated revenue streams are his to manage, but also his to value for the community. The potential outcomes here are complex. Chloe's legal team will argue that because this brand was built during the marriage, it possesses massive enterprise goodwill. This is the value that exists independently of Leo's daily labor. It is the brand itself, the contracts in place, and the historical data of the followers. Step by step, the valuation process for this intangible asset follows a methodology known as the excess earnings method. This is a technical, data-driven deep dive that forensic accountants perform to put a price tag on a person's reputation. First, the accountant determines Leo's average annual earnings over a specific period, usually the last 3 to 5 years. Second, they determine what a person with similar skills and experience, but without the famous brand name, would earn in the open market. This is the reasonable compensation figure. Third, they subtract the reasonable compensation from Leo's actual earnings. The leftover amount is considered the excess earnings attributable to his professional goodwill. Finally, they apply a capitalization rate, a multiplier based on the stability and risk of the industry, to arrive at a final value for the goodwill. In 2026, the complexity of this math has reached new heights with the rise of digital twins and automated income streams. Imagine if Leo has an AI-based likeness that continues to generate ad revenue even while he sleeps. Under the 661 presumption, if he is the one exercising control over that AI, it is presumed to be his asset. However, if that AI was trained on data and content created during the marriage, Chloe has a legitimate claim to its valuation. The court must decide if this is personal goodwill, which is tied to Leo's unique persona and cannot be sold, or enterprise goodwill, which could theoretically be managed by someone else or sold as a business. Historical trends show that courts are increasingly leaning toward finding enterprise value in digital assets, as they are more transferable than a surgeon's hands or a lawyer's legal mind. The 6.6.1 mandatory settlement conference acts as a pressure cooker, because the parties are required to present their final statements of assets and debts, supported by this complex valuation data. If Leo refuses to disclose the back-end analytics of his digital brand, the 661 presumption of ownership allows the court to assume the highest possible valuation based on Chloe's expert testimony. This often forces a settlement. Case studies from 2025 and early 2026 show that the failure to overcome a 661 presumption regarding professional assets results in significantly higher buyout requirements for the operating spouse. There is also the problem of double-dipping, which is a major point of contention in 2026 family law. If the court values Leo's brand at $5 million and orders him to pay Chloe half of that value to buy out her interest, can the court then use the same income generated by that brand to calculate his monthly spousal support? Historically, this was often allowed, but modern case studies are pushing for a more equitable approach. If the asset has already been divided as property, using the same income for support can feel like a double penalty. This is where the tactical use of the 661 framework requires a high level of forensic precision to separate the asset's value from the future income stream. As we look at these potential outcomes, we see that the 661 framework is not just about who owns a car or a house, it is about who owns the future. In the United States in 2026, your career is no longer just a job. It is a marital asset that can be appraised, divided, and traded. This professionalization of the domestic sphere has turned the divorce process into a corporate merger and acquisition in reverse. The emotional toll of having one's life's work dissected by accountants cannot be overstated, yet it is the standard procedure for anyone with a significant professional footprint. But the 661 framework and the evolution of family law don't stop at the bank account. While we have focused on the money and the machines, the most profound changes in the American legal system have occurred in how we treat the most vulnerable participants in a dissolution, the children. For over a century, the law operated under a doctrine that almost always favored one parent over the other, based on gender-coded assumptions. As we prepare to move into the next part of this deep dive, we will shift our focus from the cold reality of asset tracing to the emotionally charged history of custody. We will explore the rise and fall of the tender years doctrine and how the 661 principles of presumption are now being applied to the very concept of parenthood. What happens when the law presumes who the better parent is before a single word is spoken in court? The next part of our deep dive examines the high-stakes evolution of the best interests of the child standard and the modern battle for the 50-50 presumption. To understand the evolution of custody, we must first look back at a time when children were legally classified as little more than chattel. In the early 19th century, under English and American common law, the paternal preference was absolute. Because the father was the legal head of the household and the primary owner of all property, he was presumed to have the superior right to the custody of the children. Mothers, having no independent legal existence under the doctrine of coverture, often walked away from a marriage with nothing, not even the right to see their offspring. This was the original presumption, a world where biological relation was secondary to economic control. The first massive historical trend to break this was the emergence of the tender years doctrine in the mid-1800s. This was a psychological and social pivot that argued that during the tender years of a child's life, typically under the age of 7, the mother was the natural and essential caretaker. It was a radical shift from property rights to what we would now call biological essentialism. By the early 20th century, this had become the dominant legal standard across the United States. If you were a father seeking custody in 1920, the law essentially presumed you were unfit for the daily nurturing of a young child unless you could prove the mother was morally degenerate. This era created a gender-coded legal system that lasted for over a century, setting the stage for the massive adversarial conflicts of the modern era. As we move into the 1970s and 1980s, the tender years doctrine began to crumble under the weight of the Equal Protection Clause. The legal system transitioned to the best interests of the child standard. On paper, this was supposed to be a gender-neutral analysis. Judges were tasked with looking at a list of factors: the emotional tie between parent and child, the stability of the home environment, and the history of caretaking. However, without a formal presumption to guide them, this created what legal scholars call the judicial discretion trap. Because every judge had a different idea of what a best interest looked like, custody outcomes became highly unpredictable. This unpredictability fueled the very litigation that traumatized the children the system was designed to protect. Now let us step into the year 2026 and examine a case study involving a character named James. James is a modern father in a state that has recently adopted a rebuttable presumption of 50-50 joint physical custody. This is where the logic of the 661 framework, the concept of a legal presumption that must be actively disproven, finds its most emotional application. In 2026, when James enters the courtroom, the judge does not start with a blank slate. The judge starts with the presumption that James and his soon-to-be ex-wife will share the children exactly 182.5 days a year each. This is a massive departure from the historical trends of the previous century. Imagine if James's wife, Maya, believes that James is not equipped for this level of care. Under the 661 style of legal mechanics, the burden of proof is entirely on Maya. She cannot simply say she is the mother and therefore the better choice. She must provide specific, admissible evidence to rebut the 50-50 presumption. In the 2026 legal landscape, this evidence is increasingly digital. We are seeing case studies where parents use smart home data, shared digital calendars, and AI-monitored communication apps to prove or disprove parental fitness. Maya might present data showing that James has missed 40% of the virtual parent-teacher conferences over the last 2 years, or use biometric data from a child's wearable device to argue that the child experiences higher stress levels in James's household. Step by step, the 2026 custody evaluation process has become a forensic audit of lifestyle. The court looks at the status quo: who was doing the work during the marriage. If the 661 presumption of ownership applies to assets, a similar presumption of care applies to time. If James can show that he was the primary person exercising acts of parenting, scheduling doctor's appointments, managing the household AI for meal planning, and overseeing remote schooling, then the law presumes he should continue to do so. This has led to the professionalization of the domestic sphere. We now see the rise of parental coordinators and custody evaluators who use predictive algorithms to determine which parenting schedule will result in the best long-term outcomes for the child's mental health and academic performance. However, the historical context of 661 reminds us that presumptions can be dangerous when they ignore the nuance of reality. Just as the 661 presumption of property ownership can trap a person with poor records, the 50-50 custody presumption can trap a child in a high-conflict environment. In 2026, legal experts are debating the potential outcomes of what is known as the kitchen table settlement versus the litigated decree. Data suggests that when parents are forced into a 50-50 split by a legal presumption rather than choosing it themselves, the level of parallel parenting, where the two households operate as completely separate silos with zero communication, increases dramatically. This creates a fragmented reality for the child, who must navigate two different sets of rules, two different digital ecosystems, and two different emotional climates. Furthermore, we must address the economic intersection of custody and the 661 framework. In the United States, custody is not just about time. It is the primary driver of child support. In most jurisdictions in 2026, the child support formula is a direct function of the timeshare percentage. This has created a perverse incentive where parents fight for more time, not because they want to spend it with the child, but because it reduces their monthly financial obligation. This is the modern evolution of the property-based mindset we saw in the 18th century. Instead of the father owning the child as an asset, the parent uses the child as a shield against wealth transfer. The transition from the tender years doctrine to the 50-50 presumption represents a century-long struggle to define what equality looks like in the most private corners of American life. We have moved from a system of rigid gender roles to a system of rigid mathematical splits. But as any family law practitioner in 2026 will tell you, the math rarely accounts for the messiness of the human heart. We are seeing a rise in specialized custody arrangements, such as nesting, where the children stay in the family home and the parents rotate in and out. This arrangement, while theoretically ideal for stability, often fails when the 661 asset division takes place, as neither parent can afford to maintain a third residence for their off-duty time. As we conclude this part of the masterclass, we have seen how the legal system uses presumptions to bring order to the chaos of family dissolution. We have traced the path from children as property to children as the center of a data-driven best interests analysis. But there is one final massive piece of the puzzle we haven't touched yet. If the 661 framework governs what we own, and the custody standards govern where our children live, what happens when the two collide in the most high-stakes arena of all? The family home? In the next part of our deep dive, we are going to explore the brutal reality of the marital home. Who gets to stay? Who is forced to leave? And how are modern courts using 661 to decide who gets the keys to the American dream, when the dream itself has turned into a legal nightmare? We will examine the concept of the Watts credit and the Epstein credit, the secret financial tallies that can make or break your post-divorce future. The marital home is the crown jewel and the poison chalice of American divorce. It is the single most significant asset for the vast majority of U.S. households, representing not just financial security, but the emotional anchor of the family unit. However, in the high-stakes legal environment of 2026, the home has become a tactical battlefield where the 661 framework of possession and ownership creates massive financial shifts. When a couple separates, the first and most volatile question is, who stays in the house? Historically, the answer was often dictated by who held the title or who had the higher income. But as we look at historical trends leading into 2026, the law has moved toward a much more clinical, accounting-based approach that uses the house as a leverage point. To understand this, we must examine the intersection of possession and the 661 presumption. Under California Evidence Code 661, the person who is in possession of an asset is presumed to be its owner. While real estate title usually supersedes this simple presumption, the act of staying in the home during a divorce triggers a series of invisible financial tallies, known as Watts credits and Epstein credits. These are not just line items on a spreadsheet. They are the hidden gears that can determine if a person walks away with their retirement intact or loses it all to the walls of a house they can no longer afford. Imagine a case study involving a couple named Robert and Elena in the year 2026. They live in a suburban home purchased in 2018 for $600,000. By 2026, due to the erratic but upward trajectory of the U.S. housing market over the last decade, that home is now appraised at $1.4 million. Robert moves out in January 2026 to de-escalate the conflict, while Elena stays in the home with the children. Under the 661 framework, Elena is now the party in exclusive possession of a community asset. This possession comes with a steep price tag called a Watts charge. A what's charge is based on a simple, yet brutal, historical precedent. If you are using a community asset for your own benefit to the exclusion of the other spouse, you owe the community the fair market rental value of that asset. In 2026, the rental market for a $1.4 million home is approximately $6,000 a month. Because Robert owns half the house, the law views Elena as essentially renting his half from him. Step by step, the court calculates this by taking that $6,000 rental value and dividing it by 2. Elena now owes the community $3,000 for every month she remains in that house. If the divorce takes 2 years to finalize, Elena could walk into the final settlement owing $72,000 in Watts credits to Robert. This is a potential outcome that many spouses do not anticipate when they fight to stay in the family home. However, the legal ledger is rarely one-sided. This is where we introduce the Epstein credit. While Elena is living in the house and incurring Watts charges, she is also likely the one paying the mortgage, the property taxes, and the insurance. If Elena uses her separate property earnings, the money she makes after the date of separation, to pay these community debts, she is entitled to an Epstein reimbursement. Imagine the mortgage on this 2026 home is $4,000 a month. By paying this, Elena is effectively protecting Robert's half of the equity. Therefore, the community owes her back $2,000 a month. When you balance the Watts charge of $3,000 against the Epstein credit of $2,000, the net result is that Elena owes Robert $1,000 a month for the privilege of staying in the home. This historical trend of balancing these credits ensures that neither party is unjustly enriched by the separation period. But in 2026, with interest rates having seen significant volatility over the previous few years, the math becomes even more complex. If the mortgage was locked in at a low rate in 2021, but the rental value has skyrocketed, the disparity between Watts and Epstein can become a financial black hole for the spouse in possession. We also have to look at the historical complexity of the Moore-Marsden calculation. This is the ultimate deep dive formula for any home that was owned by one spouse before the marriage. Let us say Robert bought the house in 2015, before he ever met Elena. He put down $50,000. During their 10-year marriage, they used community income to pay down the mortgage by another $100,000, and the house appreciated by $800,000. Who owns that appreciation? Historically, the law was weighted toward the titled owner, but through a series of landmark case studies, the Moore-Marsden formula was developed to ensure the community gets its fair share. The math is precise. The community is entitled to a pro rata share of the appreciation, based on the amount of the mortgage principal that was paid down with community funds. In our 2026 scenario, a forensic accountant would determine the percentage of the purchase price that was paid off by the community. If that percentage is 20%, then the community, and thus Elena, is entitled to 20% of that $800,000 in appreciation. Even though Elena's name was never on the deed, she walks away with $160,000 in equity. This intersection of the 661 possession presumption and the Moore-Marsden equity split creates a scenario where the house is often the most dangerous asset to hold on to. In 2026, many couples are opting for what is called a Duke order, or a deferred sale of the family home. This is a historical legal mechanism named after a 1980 case study, where the court allows the custodial parent to stay in the home for a set period, usually until the children graduate high school, to minimize the impact of the divorce on the kids. But a Duke order is not a free pass. It requires a sophisticated balancing of the Watts and Epstein credits we discussed. The court must determine if the economic detriment to the outspouse, the one who can't get their equity out to buy a new home, is outweighed by the emotional benefit to the children. In the economic climate of 2026, where the cost of a new mortgage is significantly higher than it was a decade ago, many outspouses are fighting Duke orders more aggressively than ever before, arguing that their inability to re-enter the housing market constitutes a severe financial hardship that the 661 framework should protect them against. Every single decision regarding the home in a 2026 divorce is a calculated move. Do you stay and risk the Watts charges? Do you pay the mortgage and track every cent for Epstein reimbursements? Do you trigger a Moore-Marsden audit to claw back equity from a premarital asset? These are the questions that define the modern American dissolution. We have moved far beyond the days of a judge simply splitting everything down the middle. We are now in an era of forensic real estate accounting where a single year of delayed litigation can shift the final settlement by tens of thousands of dollars. But as we master the complexities of the physical house, we are forced to confront a reality that is even more difficult to quantify. We have spoken about the home, the bank accounts, and the children. But there is a silent partner in every American marriage that people only notice when things fall apart: the government. Specifically, the massive complex web of the Internal Revenue Service and the tax codes that govern how a divorce is settled. If you think the 661 possession charges are high, wait until you see what happens when the taxman decides your settlement is actually a taxable event. In the next part of our deep dive, we are going to explore the invisible tax traps of 2026. We will look at the repeal of the alimony deduction, the hidden capital gains traps in the family home, and why your choice of which assets to take could cost you 40% of your net worth in hidden liabilities. The math of divorce doesn't end in the courtroom. It begins at the tax office. When you walk out of a courtroom with a signed judgment in 2026, you might feel a sense of relief, believing the mathematical division of your life is complete. But for many, the real shock occurs months later when they meet with their CPA. The 661 framework we have discussed, the presumption that the person exercising acts of ownership is the owner, interacts with the Internal Revenue Code in ways that can silently strip away 40% of your negotiated settlement. In the United States, the tax office does not care about the emotional equity of your divorce. It only cares about the characterization of the assets being transferred. To navigate this, we must look at the massive historical shift in federal tax law that occurred in 2019 and how its full impact is being felt in the high inflation, high valuation environment of 2026. Historically, the most significant tax tool in a divorce was the alimony deduction. For decades, the payer of spousal support could deduct those payments from their gross income, while the receiver reported them as taxable income. This created a tax subsidy for divorce. It allowed high-earning spouses to shift income to a lower tax bracket spouse, effectively creating more net cash for the family to split. However, the Tax Cuts and Jobs Act of 2017 fundamentally altered this landscape for any divorce finalized after December 31, 2018. In 2026, alimony is no longer deductible for the payer and is not taxable for the receiver at the federal level. Imagine a case study involving a character named Michael, a high-earning executive in 2026. Michael is ordered to pay $5,000 a month in spousal support to his former wife, Susan. Under the old historical trend, Michael's $5,000 payment might only cost him $3,000 after tax savings. But in 2026, Michael must earn nearly $8,000 in pre-tax income just to write that $5,000 check. Conversely, Susan receives the full $5,000 tax-free. This shift has radically changed the potential outcomes of negotiations at the 6.6.1 Mandatory Settlement Conference. Payers are now fighting harder than ever to characterize payments as something other than alimony, while receivers are incentivized to keep the payments classified as support. Beyond support, the most dangerous tax trap in 2026 involves the family home and the Section 121 exclusion. Historically, a married couple filing jointly can exclude up to $500,000 of gain from the sale of their primary residence. If you are a single person, that exclusion drops to $250,000. This creates a massive cliff. Imagine Michael and Susan's home, which we analyzed in the previous section, has seen a gain of $700,000 since they bought it. If they sell the house while they are still legally married, the first $500,000 of that gain is tax-free. They only pay capital gains on the remaining $200,000. However, if Susan stays in the house under the 661 presumption of ownership and the divorce is finalized, and she decides to sell the house 2 years later in 2028, she is now a single filer. She only gets a $250,000 exclusion. She would be forced to pay capital gains on $450,000. At a 20% federal rate plus state taxes, Susan could easily owe over $100,000 in taxes that Michael never had to share. This is the hidden liability of the 661 framework. By asserting ownership and staying in the home, Susan unknowingly accepted a massive future tax bill. In 2026, savvy legal teams are now using tax-impacted balance sheets to adjust for these future liabilities, ensuring that the person taking the house receives a larger share of other assets to offset the eventual tax hit. This leads us to the concept of cost basis tracing. Under Section 1041 of the Internal Revenue Code, transfers of property between spouses during a divorce are generally non-taxable events. The assets are transferred at their carryover basis. This means if Michael gives Susan 10,000 shares of a tech stock that he bought for $10 a share, but is now worth $100 a share, Susan does not pay tax on the transfer, but she inherits Michael's $10 basis. When she eventually sells that stock to fund her new life, she will owe taxes on the entire $90 per share gain. Step by step, the 2026 forensic accounting process must account for this. If a couple is splitting $2 million in assets, and $1 million is in a checking account while the other $1 million is in highly appreciated stock, a simple 50-50 split would be fundamentally unfair. The person taking the cash gets a true $1 million, while the person taking the stock might only net $700,000 after taxes. Historical trends show that courts are increasingly willing to consider these tax consequences, but only if they are immediate and specific. If the sale of the asset is speculative or years away, many judges still fall back on the 661 presumption that the current value is the only value that matters. The 2026 landscape also introduces the complexity of retirement accounts, specifically the distinction between pre-tax and post-tax dollars. A $500,401,000 is not equal to a $500,000 Roth IRA. The 401k contains a hidden debt to the IRS. Every dollar withdrawn will be taxed as ordinary income. The Roth IRA is truly tax-free. If the 661 framework is used to award Michael the 401k and Susan the Roth, Susan has won a significantly larger portion of the actual purchasing power of the family. To solve this, the legal system relies on the Qualified Domestic Relations Order, or QDRO. This historical legal mechanism allows for the tax-free division of retirement plans, but it requires a level of administrative precision that many couples overlook. We must also consider the potential outcomes regarding the child tax credit and the head of household filing status. Historically, the higher-earning parent often claimed the children as dependents to maximize tax savings. However, in 2026, the rules for who is considered the custodial parent for tax purposes are strictly tied to where the child spends the most nights, the physical manifestation of the 661 possession principle. Even if a divorce decree says the father gets the exemption, the IRS can override that if the child spent more nights with the mother, unless a specific IRS Form 8332 is signed and filed. This creates a secondary layer of conflict where the state court's orders clash with federal tax reality. As we examine these case studies, it becomes clear that the 661 framework provides the structure for ownership, but the tax code provides the final valuation. In 2026, the professional YouTube scriptwriter or high net worth individual must understand that an asset's face value is an illusion. The real value is the net. What remains after the hidden liabilities of the state and federal government are satisfied. We have moved from a world of simple splits to a world of strategic tax planning where the timing of a signature can save or cost a family a fortune. But even with the best tax planning, there is a specialized class of assets that defies simple arithmetic. We have looked at the house, the stocks, and the support payments. But what about the money that is locked away in a vault, controlled by an employer? What happens to the pension that hasn't been paid yet, or the stock options that haven't vested? In the next part of our deep dive, we are going to crack open the most complex document in family law, the QDRO. We will explore the secret world of retirement division and why a single missing paragraph in your retirement order could result in you losing your entire pension 20 years from now. We will look at the Brown formula, the time roll percentage, and the high-stakes battle for the survivor benefit. The paper trail of your past is about to determine the security of your future. To understand the silent threat posed by retirement accounts, we must first look at the massive historical shift in how the American legal system defines work. For the first half of the 20th century, a pension was considered a gift from an employer to a loyal servant, a gratuity that had no cash value until the moment the worker retired. If a couple divorced one day before the husband's 20-year vesting date, the wife received 0% of that future income. This was the era of the expectancy, where the law viewed a future pension as a mere hope rather than a property right. This changed forever in 1976 with the landmark California Supreme Court case, in remarriage of Brown. The Brown decision established what we now call the Brown formula, and it fundamentally altered the economic destiny of millions of American families. The court ruled that pension rights, whether vested or non-vested, are not a gift. They are a form of deferred compensation. They are wages earned during the marriage that just happen to be paid out later. This shifted the 661 framework of ownership from the person whose name is on the account to the community that supported the worker during those years of service. In 2026, the Brown formula remains the gold standard for dividing defined benefit plans, and it relies on a mathematical precision that can be the difference between a comfortable retirement and poverty. Imagine a case study involving a character named David, a high-level project manager for a major defense contractor. David started his career in 2012, married his wife Sarah in 2016, and they are now finalizing their dissolution in May of 2026. David has 14 years of total service with his company, and 10 of those years occurred during the marriage. Under the Brown formula, the court applies the time rule percentage. This is a fraction where the numerator is the amount of time David worked for the company during the marriage, and the denominator is the total amount of time David has worked for the company up to the date of the division. In this 2026 scenario, the fraction is 10 divided by 14, which equals approximately 71%. This 71% is considered community property. Since Sarah is entitled to half of the community's interest, she is awarded 35.5% of David's future pension. Step by step, the court does not give Sarah a lump sum of cash today. Instead, it gives her a right to receive 35.5% of every pension check David ever receives, starting on the day he retires. This historical trend of the deferred division creates a permanent financial link between ex-spouses that can last for 40 or 50 years. However, having a court order that says you own 35% of a pension is useless if you don't have a qualified domestic relations order, or QDRO. Before 1984, the American retirement system was a legal fortress. Under the Employee Retirement Income Security Act, or ERISA, a pension plan was strictly forbidden from paying money to anyone other than the employee. This created a crisis where state courts were ordering pensions to be split, but federal law was preventing the pension plans from actually sending the checks. This led to the Retirement Equity Act of 1984, which created the QDRO, a specialized legal key that unlocks the federal fortress of ERISA. In 2026, the QDRO is the most dangerous document in a divorce file. It is a separate, highly technical order that must be approved by the pension plan's administrator before a judge even signs it. If the QDRO is drafted incorrectly, the plan administrator will reject it, and the non-employee spouse could be left with nothing. Consider a historical case study where a spouse was awarded half of a 401k, but the QDRO failed to account for market gains or losses between the date of the divorce and the date of the actual transfer. If the market crashed during that 6-month window, the employee spouse could be forced to pay out a fixed dollar amount that no longer exists in the account, leading to secondary litigation that costs tens of thousands of dollars. The most high-stakes battle within the QDRO, however, involves the survivor benefit. This is the silent killer of retirement settlements. Imagine if David, our project manager, dies in 2030, 4 years after the divorce but before he ever retires. If Sarah's attorney did not specifically include a provision in the QDRO naming her as the surviving spouse for her share of the pension, the entire community interest could vanish. The pension plan might simply keep the money, or it might all go to David's second wife. In 2026, the distinction between a separate interest QDRO and a shared interest QDRO is a critical point of the 6.6.1 Mandatory Settlement Conference. A separate interest QDRO effectively carves out Sarah's piece of the pension and treats it as if it were her own, allowing her to start her payments even if David keeps working. A shared interest QDRO only pays Sarah when David decides to collect his check, leaving her financial future in his hands. As we look at potential outcomes in the year 2026, we must also address the rise of the digital age retirement asset, the Restricted Stock Unit, or RSU. In the tech-heavy economy of the United States today, many high earners receive the bulk of their compensation in stock that vests over 4 years. This has created a new evolution of the Brown formula, known as the Hug formula and the Nelson formula. These are the mathematical tools used to determine if an RSU was a reward for past service or an incentive for future service. If David's company gave him 5,000 RSUs in 2024 to stay with the company through 2028, the court must decide how much of that stock belongs to Sarah. Under the Nelson formula, the court looks at the date the stock was granted versus the date of separation. If the grant happened during the marriage, but the vesting happens after the divorce, the community still owns a pro rata share. In 2026, with tech valuations seeing massive swings, the timing of the date of separation can shift the value of an RSU division by millions of dollars. A single week's difference in the legal end of the marriage can determine who owns a massive block of vested stock. This brings us back to the 661 framework of evidence. In 2026, the presumption that the worker owns the stock because it is in their name is constantly being challenged by the forensic tracing of vesting schedules. We are seeing case studies where employees try to backload their vesting schedules, asking their employers to delay stock grants until after the divorce is final. This is known as breach of fiduciary duty. Under the historical context of marital law, spouses owe each other the highest duty of good faith and fair dealing. If David hides a stock grant or intentionally devalues a community asset, the court can award 100% of that asset to Sarah as a penalty. We have now traced the history of how the American legal system captures the value of a person's labor and locks it into the community. We have seen how the Brown formula and the QDRO ensure that the future is divided as precisely as the present. But as we